With opening statements in this matter.
How's the volume?
This time, counsel for the parties may have an opening statement. Opening statements of counsel are concise and orderly descriptions of each side's claims and defenses and the evidence counsel expects to produce in support of those claims and defenses. They are not evidence. Each side will address you once during opening statements, with the state going first. Is the state ready to proceed with opening statements?
We are. Yes, we are.
Is defense ready, Ms. Scott?
We are ready, thank you.
Mr. Stratton?
Yes, sir.
The state may address the jury.
The state, that's Julie.
May it please the court, opposing counsel, ladies and gentlemen of the jury,
Julie.
good morning.
Good morning.
Again, my name is Julie Cook Hutchinson, and I, along with prosecuting attorney Shane Tiemann, represent the state of Ohio. Before we discuss what it is that the state must prove and what we believe the evidence will be, I too want to thank you for your service. The service that you are about to complete here on behalf of your community is very vital to our American justice system.
Thank you, Julie.
I also want to apologize to you in advance.
Ooh.
The case you're about to hear is a difficult case. You're going to see, hear, and learn things that you cannot unsee, unhear, or unlearn. And for that, I'm sorry. Having said that, let's discuss what the charges are in this case.
Julie's a great attorney. If you've been on my channel for a while, we've seen plenty of opening statements. Opening statements of some of the craziest cases, but the prosecutor just can't come through. I don't know if it's because I'm already captivated by Julie, but I feel like I want to listen to her. Like, she as a prosecutor has really made me want to hear what is she going to say next. And dude, I love a good attorney.
The defendants, Daniel and Jessica Groves, are charged with 11 felony charges.
11 felonies?
His Honor, Judge Kuhn will instruct you on the law that you are to follow throughout this trial. If something I say differs from what something he says, you are to follow His Honor's instructions. You heard in voir dire the phrase, being in cahoots with someone. And you also heard in Ohio that the legal term for that is complicity. Mm-hmm. His Honor may instruct you that the defendant or defendants can be found guilty of the offense charged as a principal offender, in other words, the person who committed that crime, but also can be found guilty of that principal offense in complicity.
That's right.
In other words, they don't have to be the person who actually committed the crime. But
basically what she's saying is you may not have been in cahoots with the person that carried out a murder or assault or something like that, but if you sat there and watched several times, you're complicit and you're just as guilty. And my God, do I agree with that.
Complicit to that person or in cahoots with that person. You may be further instructed that complicity means aided or abetted.
Aided, emotionally. She emotionally supported him and hurting that child. She did it too. Bring it up, Julie.
And you may also be instructed that aiding and abetting includes supporting, assisting, cooperating with, advising, inciting another to commit a crime. Complicity also includes conspiring with another person to commit a crime. State of Ohio versus Daniel Groves and State of Ohio versus Jessica Groves charges each defendant with the following felony charges. Aggravated murder.
That's right.
Requires the state of Ohio to prove beyond a reasonable doubt that the defendants did or were complicit to purposely causing the death of baby Dylan, who was under 13 years of age at the time of the offense.
That's right.
Defendants are charged in count 2 with murder, which requires the state of Ohio to prove that the defendants did or were complicit to knowingly causing the death of baby Dylan as a proximate result of committing or attempting to commit a felony offense of violence that is a felony of the first or second degree.
Now, I just want to remind you guys, if you haven't, 1 in the chat if you're familiar with this case, 2 in the chat if you know nothing about it. If you're just coming into this, Julie does a great job of doing her opening statement, but my God, does this woman get passionate. That's what's coming up here soon. As soon as Jessica Groves starts with the waterworks on it, Julie's like, we're not doing that. I think she literally, didn't she do the point? Didn't she point too?
In count 3, the defendants are charged with kidnapping. Kidnapping requires the state of Ohio to prove that the defendants did or were complicit to, by force, threat, or deception, or in the case of a victim under 13 by any means, remove baby Dylan from the place where he was found or restrain his liberty for the purpose of hindering, impeding, or obstructing a function of the government. Count 4, child endangering, requires the state of Ohio to prove that the defendants did or were complicit to, as a parent, guardian, custodian, person having custody or control, or in loco parentis of a child under the age of 18, create a substantial risk of health or safety to baby Dylan by violating a duty of care, protection, or support, and that violation resulted in serious physical harm. Count 5, the defendants are charged with tampering with evidence, and that requires the state of Ohio to prove that the defendants did or were complicit in knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence. Document or thing
said y'all about to
with
witness the
purpose to
beat down
impair
of the
its value
century.
or availability as evidence in such investigation. Count 6
Thanks,
charges
Patricia.
the defendants with interference with custody and requires the state of Ohio to prove that the defendants did or were complicit to, knowing that he or she had no privilege to do so or being reckless in that regard, entice, keep, or harbor baby Dylan from a parent, guardian, or custodian of a child under the age of 18, and that baby Dylan suffered serious physical harm as a result of that violation.
Lay it out, Julie.
Count 7, gross abuse of a corpse, requires the state of Ohio to prove that the defendant did or was complicit to treating baby Dylan's body in a way that would outrage reasonable community sensibility.
The way that somebody treats an individual after they, I mean, it sounds crazy to say, after they've killed them, you could give me all the waterworks in the world. You're going to see Jessica Groves sit here crying over what happened to Dylan, saying it was an accident, I didn't mean to. Well, then why did you try to conceal the body? Why did you put the body in some makeshift crate and bury it where no one would find it and then not talk about it at all afterwards and then continue on with your life and keep doing drugs and in fact doing more drugs now because you don't have your kid?
I'm only human. I made mistakes. Don't put the blame on me.
The way somebody acts afterwards really solidifies how they felt about everything.
The remaining counts 8, 9, 10, and 11, are counts of felonious assault. And they require
Julie's
the state
really
of
keeping her
Ohio to
composure
prove
here.
that the defendants did or were complicit to knowingly causing serious physical harm to baby Dylan. On January 10th,
Dylan time.
2019, in the early morning hours, the defendants Daniel Groves and Jessica Groves arrived by self-transport at the emergency department of Southern Ohio Medical Center
So they drove
here in Scioto County, Ohio.
to the hospital.
Several hospital employees will testify here. They will testify that for Jessica, labor was nearly complete upon arrival,
She's getting mad.
as she was dilated 9.5 out of 10 centimeters. They will testify that Jessica Groves refused to answer any questions and that a urine sample had to be taken by straight catheter.
That means they were on drugs while she was pregnant. They were on drugs when she was going into labor. I don't think they cared whether this baby came out alive or dead. That's the thought I'm getting. It sounds to me like Jessica eventually was in so much pain that she was like, all right, let's just go to the hospital. But she doesn't want to help the nurses and doctors take care of her because she knows she's on drugs, but she knows she's in pain, so she just wants to get to a hospital. She waited till the last minute. Most people go to the hospital when they're in labor.
The testimony will be the hospital staff administered no pain medications to Jessica Groves for several reasons. There were no medical records of prenatal care.
Oh! She didn't take care of the baby at all.
Jessica appeared to be under the influence but refused to answer any questions about what substances she may have taken.
No cooperation with
And
medical
not giving
staff.
medications enabled the staff at the hospital to determine what had been ingested pre-admission so that they can care for baby Dylan once he was born.
Oh my God. So they basically let her go into withdrawal to see what she was on just so that they could have the baby. Oh my